practicing law in California. I'm certified by the California State Bar Association Board of Legal Specialization in 1980. So no one in California has been a certified family law specialist longer than I have. We're doing a video on how to get organized to do your own trial. And this video is for people who are representing themselves, and it would be a good thing if everyone could afford an attorney. But as we go through trials, we find that more and more people are having to represent themselves. And if you find yourself in that position, this video is going to be useful for you. It is also useful for people who are already attorneys. They are going to find themselves learning new ways of being more organized. And this is going to apply to people who have big trials and people who have small hearings coming up. In fact, this applies to people who have a small hearing, and your papers will fit in an accordion folder. It will apply to people who have a box of files. It will apply to people who have several files and they fit on a dolly. And I assure you, I have used my trial in a box method where I have people bring in series of dollies carrying boxes. So whatever size of hearing or trial you have, this video will help you do your hearing or your trial, and it reduces the task from the impossible task of do a trial. How do you do a trial? Down to the doable task of go through the series of file holders in the box in order. That's something that an actual human being could do. And we're going to show you today how you can actually do this. And now, this videotape begins at the point after you have gone through your case and you have collected the evidence and you are now ready to go to trial. But I find a lot of times in my cases, people come into me and they bring their records to me, and here they are. And here are the records. And I understand you may be in that position. It's all right. You can do your hearing even if you're in that position. And the first thing you have to do is get organized. You have to get your papers out of the chaos they're in and get organized. Step one, you don't keep your papers in envelopes. You get the papers out of the envelopes, get them flattened out, put them like this, get them organized, staple the papers. Staples do not kill documents. Losing papers off the back of the documents will kill you. Staple all your documents, okay? Get them flattened out, stapled, no matter whether they are scattered all over the house, get them into the bag, then get them out of the bag. And we hope that we get the papers in a little better order. But if we don't, that's fine. We will show you now how to get it to trial order. We can hope that during the case, you may have been keeping your papers in better order. But even if you've kept them in better order, you're going to have to get out of pre-trial order and into trial order. Pre-trial good order is evidence, and of course it may not be a file folder, it may be a notebook, it may be a box, it may be a notebook, maybe whatever, but you have your evidence, you have your notes, which of course nowadays more and more may be on disc. And we're glad when you bring them into us that way. You have your court papers, which is whatever has been filed in the courthouse, and you keep those in chronological order with the earliest papers on the bottom and the most recent papers on the top. You have your letters, again, oldest on the bottom, most recent on the top, and this one also has a law flag. That's how, if you have been keeping your papers in a good pre-trial order, that's how you will have been keeping your papers. You are now going to have to shift from that into trial order. The gist of trial order is going to be based on organizing by the person, because when you're sitting in the courtroom, everything is going to be based on calling people as witnesses. So although before trial, you had things based on chronology and analysis, now when you're in the courtroom, it has to be based on how things flow in a courtroom. And of course, although I've spent my life in a courtroom, you haven't. So my job is to connect you to that courtroom. And you're going to make a file for every person in your case, and you're going to make a file for every person that you think the other side might call to, because you don't want to get surprised in that manner. Now, I'm going to take you through an entire case and show you how we do it. And what's going to happen is you are going to be so prepared that if you walked into the courtroom and you forgot everything, you will be so prepared that you could simply stand there and read what you have written down. You will, but the result of that will be that you will not panic, and you will be so calm that you can go through it and do a very good job. And it won't surprise me if you do a better job than many attorneys would have done, because you are going to be very prepared with the trial in a box method. Now we're going to start with our witness list, because when you start out your case, you're going to have to list your witnesses. Now, I have here a couple of cases where I have done hearings and have used the trial in a box method. Trial in a box is not something I use to teach classes in a college. Trial in a box is something where I go into a courtroom and I pour out my blood on the courtroom floor fighting for you. And I have two cases here, a custody case and a financial case. And we start out with a witness list. I'm starting with that because many courts require you to file your witness list in advance. This one was filed in advance. It has my notes here on the side, but it is filed endorsed because we filed it with the court in advance. And in many cases, and you have to check your local court and your state court, in many cases, if you do not file and serve your witness list well in advance of your hearing with the name, address, and the substance of the testimony, and possibly all the exhibits that will be used by the witness and any report they generated, you will lose the right to have witnesses. In California, there is a state rule that requires that in hearings of motions and orders to show cause, if you do not request witnesses in advance, file and serve, and justify in advance why you need oral testimony as opposed To written testimony, the judge will limit you to written testimony, and you need to be ready to proceed by written testimony. I have seen a case where I have seen more than one case. These people come to me after other attorneys have wrecked their cases. I've seen cases where people had attorneys and didn't know this. And they went to trial ready to present their case, and the judge said, "Oh no, you didn't file your documents before court. You get no witness list." And the other side gets custody of the child. In as important an issue as custody of the child in some counties in California, you may get no witnesses and no opportunity to present evidence if you do not follow very specific rules. So your request for oral testimony and presenting written testimony may be extremely important. So you have to check all of these rules in advance, local rules and state rules. State rules, www.courtinfo.ca.gov/rules. Check them out. Check your local court website. And if there are local rules that require you to disclose in advance, disclose. The state rules do require this. Okay, so I've got, and at trial, even at trial, they may require this. We have a witness list here, and I often use 2 witness lists. One which I file with court, and another one that is my private witness list that lists the date and the exact time of the witness, and I have their phone number, their cell phone, and everything, so that I know exactly when I'm going to call that witness. And you need to be ready because, and you'll see this one here has dates and times next to it, and you have to be ready for the validity of a trial, which is sometimes the witness's testimony goes very fast and sometimes it goes very slow, and you have to be ready to make changes if they don't go exactly at the speed you expected. Now, when you do your witness list, I'm assuming a big case here. Now, you may have a simple case. It may be the situation that you're doing a family law case, and it's just you and your spouse, and you don't really have any other witnesses. But I'm doing the full thing today because that's the hardest one. If you could do the hardest one, of course you could do the easiest one. But we're doing the hardest one today. Now, when you're doing a full witness list, the skeleton of your witness list is your professional expert witness. You're paying them, so you want to get them in and out. And they're very busy people. So you have to find out in advance when they're available. In fact, when you set your trial date, you have to find out if they're available, because if you had a custody case and you set your custody trial at a time when your expert will be on vacation in the Bermudas, you're going to have a problem. So you have to call your expert and check with them when you set your trial date. You have to get there on the day you're going to go to court and set a trial. You better have your expert's vacation schedule in hand. So you set your trial at a time when you know they're available. And then when you've got a trial of a number of days, you set them at a particular time. So your experts are the bonus in your trial plan, and then you fill in around them with friendly, unpaid witnesses, such as family and friends, you can afford to have them sitting in the hallway, not getting paid, and you plan your schedule accordingly. So that's your witness list, and you get it filed and served well in advance, and your witness list kind of amounts to your trial planner, and you're going to have a file for every single one of those people who's on your list. Now, you as a person who is going, and you see this was right out the front of my trial in a box. I use it too. It's for real. You need it. you as a person who is going to court without an attorney probably need a trial assistant or a helper, because you're standing up here talking to the judge and you've got witnesses subpoenaed and they're appearing, and you may have a situation where witnesses are excluded. So they're out in the hallway, they come and there's a sign on the courtroom door that says witnesses excluded. So they sit down out in the hallway, you don't know who's there, and you can't go out and look, and you're getting nervous, and you don't know, like if you're questioning a witness, should you draw this person out because the next one didn't arrive, so you better stall, or the next one got there, so you better hurry up and get them in. You need an assistant to help you. So you've got to find someone who's reliable, patient, as in, whatever time your trial's going to take, they need to be able to take that time off of work and come and be with you in the courtroom, and they'll make a good impression with the judge, and they're not going to be one of your witnesses. Because if they're one of your witnesses, they can't be running in and out. Just a friend who's not involved in your case. So your friend is going to be there and be going in and out. So one of the other things that you have at the beginning of your case is a file that you call prelims. And one of the, at the beginning of each case, you have certain things you have to do. And one of the things you're going to put is a piece of paper in here that says, ask the judge if so-and-so can be my trial assistant. And you've called your friend, you've got them all lined up, they come to the first day of trial, and in your prelim file here, it's going to say, ask the judge if so-and-so can come in. And you want to have it all thought out in your head, how you're going to explain to the judge, the witnesses will be outside and I need so-and-so to be able to go in and out, use the cell phone, and I don't want to bother the court and disrupt the proceedings. And I will need this trial assistant to be able to go in and out, and you'll be giving your subpoena files and all that kind of thing to your assistant so they can handle it. I mean, if you give the judge a good, clear explanation, it ought to work. Will it work in a juvenile court confidential case? I think it would, because there is a clear need for this, and if the judge has want things to go smooth, I think they should do it. Okay, and now the next thing that you're going to need in your handy-dandy box here is an exhibit list, and there are two types of exhibit lists. The judge the state rules or local rules may well require you to exchange exhibits and file and serve an exhibit list in advance. And if that's the case, your exhibit list will look like my witness list that I showed to you, the file and serve. And you also will have an exhibit list that you're going to have with you at a counsel table. And I have one that I use. I have my own that I generate by computer, or you could have one that you do by hand, like I used to do in the old days. And if you have to do one by hand, what you're going to have, you label it at the top, exhibit list. Just bring an extra legal pad with you. Don't try to do this on the legal pad that you're taking your notes with in the courtroom. You have a separate one and you write exhibit list. Over here you have a column labeled ID, because when you first deal with your exhibit, you will have it marked for identification. Let's see, we have a set of exhibits here. This, of course, is a case we actually did a trial in, and we have documents here that were actually used in the courtroom. So we have them with your exhibit tags on. And this is an exhibit tab that is marked for identification. Exhibit A, right here, And so the clerk gave that one the number A. So when it's marked Exhibit A, you will write A in your identification column. The next two columns say in EV for when it goes into evidence, and it also says number in case it's when it's numbered, it's A, B, C, D. An item. So this one, when the clerk marks it for identification, you check that one. When it goes into evidence, you check that one. If it's Exhibit A, you put down an A. And this one was a notice to compel, so you can put down notice to compel on your list. Now, of course, I find it handier to go in with a computer-generated list and mark my exhibits in advance so that it reduces the things I have to think about in court. So that I have my exhibit list and it's got the item and the number A, B, C, D already. And if it turns out that for some reason the numbers get changed, I can always cross them out. And I can also generate it on the computer, and I have my number and I have my columns that I can check the columns at court. Of course, the computer won't have checked them in court, but you can come in with the letter from Esther Smith dated July 4, 2002, number 1. And then these are blank. And at the end of your case, oh, this one doesn't say it went into evidence. At the point of this list, if your item does not go into evidence, the judge isn't going to look at it. I don't care, it has all the fancy markings, it has the neat super duper tag on it, the judge is not going to look at it. If his list doesn't have a check mark in the in evidence box, no judge in California is going to look at it. So the whole point of this list is that at the end of your case, when the judge says, "Are you done?" you look at your list and you say, "Oops, I didn't introduce Exhibit 3, Your Honor. I would like to move the MasterCard statement dated May 5, Exhibit 3 into evidence." And the judge says, "Granted," or you can argue about whether it's hearsay or whatever, but you get everything into evidence. Or at the end of your case, you say, "I want to move everything into evidence." But you'll be using this as a checklist, and when we do our class on how to do a trial, we'll go over that. But the point now is how to get organized for trial. You bring your exhibit list. You get all your exhibits ready, and you bring your exhibit list. You have a question. We're doing class. Can we do a question? You can do a question. We can always cut it out if we don't like it. Okay.
If you submitted all of your evidence along with your motion or whatever you're doing to the judge again, so they just get everything out scripted on you, do you still have to go with it?
Okay, that's a good question. The question is, if you attached documents to your motion papers or your OSC papers or your settlement conference papers, do you have to then bring it in at the trial or hearing? Yes. Your trial or hearing stands alone. You have to be prepared to do this all standalone separately. And of course, we're dealing with the hard case. Now, if the judge, sometimes judges in family court will kind of slide into formality and consider things that are attached to motions. But in reality, under the law, just because something is in a file doesn't mean it's in your trial. Just because it's in the file doesn't mean the judge is considering it. You have to bring it all in at trial. You have to get it all in. Just because something is in the court's file doesn't mean it is properly considered at trial. And we will at the trial class and the trial video show you how to get things into evidence. But basically you need to bring all your evidence to trial, bring all your evidence to hearing. Just because it was brought earlier doesn't mean the judge knows it. Just because Family Court Services has it doesn't mean the judge has any idea in the world that it exists. You're going to put it on a list, you're going to copy it, and you are going to present to trial. Many judges will pre-mark the exhibits when you go to trial. I'm about to bring it all.
And so you have to verbally introduce each piece of evidence?
That's right. That's exactly right. And when you're at the trial, one of the things that will be important is to make sure the evidence stays in the courtroom, because sometimes a witness will testify and the witness will be sitting there on the witness stand. And they're looking at the piece of evidence and they're testifying about it and talking. And when they get done, they gather up their things that they may have brought and they walk off with your evidence.
Cool.
It's really, and the clerks are pretty good about watching and making sure they don't do that. But it's also a good thing if you make sure, and you may even say to the witness, be sure you don't take that with you. It's okay to say that because you don't want to find that at the end of the case, the evidence is at their house. And you also, when I was a new attorney, every now and then you'll wake up in the morning and find out you walked off with the evidence. And the clerks will let you bring it back, but it's really better if you make sure and leave the evidence in the courtroom. Okay, now you have in each case, right at the front, you're going to have your prelims file, your preliminaries. And preliminaries includes excluding the witnesses because you don't want the other side's witnesses to sit there and listen to each other and, shall we say, adjust their stories accordingly. Not as people would lie, but, okay, don't have them listen to each other. Another preliminary question in many custody cases would be whether the judge will talk to the children and under what circumstances. In chambers, in the courtroom, what are the circumstances to be? So if you want a question like that addressed, that would be addressed in a preliminary question. There are also things that are called, in California at least, that are called motions in limine, L-I-M-I-N-E. That basically just means those are the kind of motions that are left to the last minute. Judges are allowed to control their trials, and it's believed that the judge should be able to control his own courtroom, and evidence questions are particularly left up to the judge so that he or she will be allowed to decide who is going to testify, how they will testify, etc. So the kind of question like, will a particular witness be allowed to testify, or will they be excluded because something happened late? That kind of issue gets addressed by a trial judge in a motion in limine sometimes. Now, it sometimes happens if you're without counsel and the other side has an attorney. You come to the trial and a bunch of motions in limine get dropped on you at the last moment. Are you going to panic? No. First of all, you may have been listening and hearing little rumblings of things like that coming at you. So you got ready for them and you dropped any law that you had on the subject into your prelims file so you know right where to fight. And you are ready for motions in limine. Second, you should ask for a continuance if that's necessary. And third, if someone throws a bunch of motions in limine on you, you take time to read every word. Do not worry about looking stupid. You will look a lot stupider if you don't read the motion. So take the time and do not worry if the judge is pressing you and acting hurried. You just say, Judge, I read slower. And just take the time you need to read the motion. It is part of due process of law to have notice and an opportunity to be heard. And this is also a good time to say words like due process of law to the judge in the presence of the court reporter. And just do your best that you can to handle emotions. Okay, now we're going to deal with the question of how to prepare for individual witnesses, because this is the gist, the heart and soul of the trial in the box method. And it is basically what you're going to do when you do trial in a box. And what you are going to do is what I have done in these cases. And you get, as you've been going through the case, you have gotten documents that pertain to different people, and you have to take them out and put them in order. Now, this case that I did here, this is an example of a financial trial. And I might say this one went very nicely because the husband was making quite a bit of money, and he brought in an accountant, and the lady couldn't afford even to pay me in advance. And I made one of my extremely rare exceptions and said, okay, I'll take you to trial and we'll do our best here. And he brought in his accountant. And as I'm cross-examining the accountant, I said, well, the client says to me, I haven't seen his 2002 tax return. And no, 2001 tax return. And I said, well, unusually I'd be discovered that the lady had no money to do this in advance, so we just went in and did our best. So I said to the lady, the accountant, who was the lady, do you have the 2001 tax return? And she said, yes. And I said, have you brought it with you? And she said, yes. And so I got up to look at it. And I said, oh, no, will you read the income to the court? And she said, the adjusted gross income there. And she said, 6 million. Oh my God. The judge's only question at the end of this child support modification hearing was, how does it affect the case if one of the parties has won the lottery? So the case turned out quite well for my client. Okay. But we got all organized. We did everything like we should. And we went in with our exhibits. And here's our exhibits as we have them here. And we had law, which we weren't prepared to argue. We had our exhibit list. We had pictures of his home in Santa Cruz Mountains and pictures of the home in Tahoe. Oh, yes, we have pictures of the little shack the child was living in. We had our computerized support program based on what we knew about his income. Boy, did that turn out to be wrong. Redid that one. We had my request for attorney fees. Oh, that was granted, it turned out. And I use color coding, I might mention. How that could have. In my office, I find that it is helpful to use color coding because when you're in court, the one who grabs first often is the one who gets to answer the judge's question first. And you want to be the one who answers the judge's question. So in my office, we use red for assets, yellow for debts, green for tax returns, because that's where you find the money, and blue for all support issues and attorney fees, and then orange is where we put our subpoenaed documents. And so that's why you see colored files in here is we use the color coding to help us grab things fastest in court. Of course, you may want to do that, but that's calling for probably high level of organization. And we use vanilla files for miscellaneous and courtroom organization. So then we came to documents that had been subpoenaed as Wells Fargo Bank, the prior employer, we love to subpoena credit cards. People who are saying they have almost no income, and I just have no income, and my visa is $8,000 a month. Stock that Schwab accounts were subpoenaed, and then of course you have your regular files of notes and correspondence and court papers kept in chronological order. And when you go to court and you have your trial in a box file kept in this order, this was a case that didn't have a lot of witnesses. As you can see, we had documents that we subpoenaed, the two parties testified, and there was an accountant. And the attorneys put in papers to show how much they thought they should give for attorney fees. That was all. It was, the husband saying he had no money, and the wife saying to me, the ex-wife saying, I really think he does. And this was a fairly simple case, but we were able to organize it and have it all in court at hand. I was new to the case. I just came in at the last minute, but I went in with a feeling that I knew where everything was because I used trial in a box method, and it came out successfully both for me and for the client. And here's another example of trial in a box. This was a custody case, and you go in, and at the front, this case didn't go to trial because it was so organized. I came in a case that another attorney had prepared, and it looked like it was going to trial. Sometimes other attorneys bring me in as a litigator, and we came in, I prepared the witnesses, and there were a lot of experts, and we settled the case. And we get the front, you have your witness list, and then we had our exhibit list, and then we didn't have a log file in this one because there were so many detailed legal issues that we had a hearsay file, and this is also a good file to have transcripts. I've got TRX. For me, you list, when you make your file tabs, write on the files right next to the top of the file. You don't want to write in little tiny writing way down low, and then one paper in the file gets out of order and it covers up what you've written. When you're in the courtroom, you want to be able to glance at that file tab and you see it. And don't worry that the other side might see it, because your case is going to be so strong. You are rolling them over. You're rolling over them like a steamroller, and they can't resist you. Okay, your case is going to be that strong and that logical because you're right. It's not based on trickery and surprise. It's based on good homework, solid preparation. You tried to negotiate, you tried to settle the case, and the only reason you're going to trial, I hope, isn't the other side was unreasonable. That's the only reason I go into trying. Now you have a transcript file, so that if you've been in court before and if you have transcripts, you can find them easily. And then we had, in this case, there were trial briefs where it was a complicated trial, and we had summarized everything at the last minute legally and factually. And then we went through, and each witness had a file. And in that file, we take every document that pertains. Now, let's say you have a custody report in a case. You have that report is going to end up in the file of the person who made the report, But then you go through and you chop up the report. And one page mentions father. That page goes in his report. Well, the page also mentions, it goes in father's file. That page mentions mother. It goes in mother's file. The page mentions the child. It goes in the child's file. The page mentions the pediatrician. What he said goes in the pediatrician's file. So you may make 5 copies of that page. And you also have to be clear where the document came from. It's not going to do you any good if you cut a paragraph out and you stick it in somebody's file and you're sitting in the courtroom thinking, I wonder what that is. Because it's not going to do, okay? You're going to have to, usually I go in my computer and make tags, say, Dr. So-and-so's report dated such and such, and then I, if I start cutting the pieces out, or, at the bottom it may have something that says what it is. You need to know what it is. You don't just start cutting the report all up and then you get to trial and you can't tell the tone what you got. But you need to do that. Now the other thing, speaking of knowing what you got, when documents come in during the case, you need to be sure that you know what they are. In other words, you're going to receive documents in a package from a subpoena, and when you get documents pursuant to a subpoena, you keep one set packaged up in the subpoena that you got for the request for production. Here's an example. We have a big request for production of documents here, and it has a big response, okay? We have little numbered tags down the side here where the person gave us number 1 something, number 2 something. That's great. But we can't just leave them in this stack. We can't go to trial, and if we find out that we need the Merrill Lynch CMA here, I can't go running back in the courtroom and start looking for things like this. What we have to do is when we make our trial plan, if the documents in here are important, they have to be in the person's file. They have to come out of this stack and they have to go into the person's file. So what we're going to have to do here, here's the tax return. There's a good example. A 2000 tax return. We have our little tag here. This says received from, and it's got the person's name, with production response on date. We put a whole bunch of these tags up in our computer. Here's what we're going to do. We're going to make a copy. We don't have a copier here, but oh well. We're going to make a copy of this tax return. We're going to take a tag that says, I received this from whoever the person is we got it from with the tax return, and we're going to put our tag on. And then we're going to we'll call it husband. Let's say husband produced that to us. We're preparing for trial, and here's our file with husband's name on it. And when we were doing our discovery in the case, husband gave us his income tax return. We made a copy of it. We put a tag on it so we know where it came from, and we put it into his file. when we actually come to going to trial, we're going to make 2 more copies that are going to be behind it, because when we go to trial, we need an original and 2 copies of everything, one for the judge, one for us, and one for the other side, which in the example of this case would be the husband. So now we have, when we go to trial, we don't know, when you go to trial and you sit in the courtroom and you show this document to him and you say, "Isn't this a copy of your income tax return?" You know what he's going to say to you? "I don't know." That's what they all say. "I don't know." And so you have to be prepared to say to him, "You gave me this." Okay? So the judge doesn't want you to hand the judge a big stack of documents. What the judge doesn't want, first of all, he doesn't want you searching through a big stack of documents in the courtrooms to find the tax return. Secondly, he really doesn't want you not knowing what you're doing. You cannot go into the courtroom with this big stack of stuff. You have to pull out the tax return, make copies of it, and have it in the husband's file. But when you say to the husband, "Isn't this your tax return?" and he says, "I don't know," you have to have this in the back of the courtroom and you say to him, "I have here a request to produce." The first time he does it, see, this will stop it. After he does it once, you say, "Okay, I have here a request for production of documents which was served on your attorney by mail on September 6, 2002. Correct? You see that, correct? Now, you signed a verification where you produced documents in response to that request to produce. You recognize your signature here, correct? Correct. Now, under item number 5, you see your income tax return here, correct? Correct. And that income tax return is in fact identical to exhibit number 5, which I have introduced, which I have marked for evidence, right? Right. So the judge will not care for his motive. So once you do that about once, he'll stop with the, "Gee, I don't know if it's my income tax return." So, but you have to have the whole thing standing there and ready to do that. Because if you just walk in, if all you do is you copy the income tax return that he signed and you didn't sign, and you put it in this file, and you say to him, "Is this your income tax return?" He'll say, "I don't know." And if you didn't take the little tag, the way I showed you to do, and put it on here, and you don't remember where you got that income tax return from, you're going to have a hard time. But if you get your trial in a box method the way you're supposed to, you're going to steer over them.
Dr. the discovery thing, per se, that you have one for your file, your husband's file, and then you need one for the court that has time that this is
In May, some require it, some don't. Yeah. Okay. Now, what you're going to end up with when you've done your discovery, you end up, you got your requests to produce as you're going along, and you kept one stack of the request to produce or the documents that you got from a copy service in absolutely pristine, unmarked, do not ever mark on the evidence or leak through the video and tell you. You keep one copy exactly as it was originally, and you keep one that you pull apart and you put into each individual's file. And you do that with experts, reports, whatever, so that every page that relates to an individual in your case, whether they're on your side or the other side's side, you make a file for everybody who conceivably might show up at this trial. If it's a custody case, your mother-in-law, your father-in-law, their grandfather, everybody who you think might show their face in this courtroom and is mentioned anywhere in any document, you're ready for them. You're not going to start looking around for a police report that had to admit, oh, that police report, I know it mentioned them, I think. There's going to be a file on them, and you can hold it out, and you will have it right at your fingertips. I generally I put my witnesses' files in the order in which I'm going to call the witnesses, and I put the opponent's files in the order, in alphabetical order, because you can't anticipate the order in which they're going to call their witnesses. Okay, you want to stop for a second? Britt. Okay, are we done? Are we going?
Yep.
Now, one of the things you're also going to put in the witnesses file is if you have anticipated a problem with introducing the witness's testimony, such as if something they're going to say is hearsay, or maybe hearsay, or if you want to object to the other side introducing hearsay evidence, then you'll have some law in that witness's case. So you may have copies of hearsay code sections and things, such as if you've consulted with a lawyer and you've given you some advice, that law will go into that witness's file. So everything to do with this witness, with the law, law about them, everything is in their file. Now, what you want to do is type out in 16-point type your questions for the witness. And what I do in my scripts for myself is I underline every place in which I come to a piece of evidence. So if I said, is this your 2001 income tax return? I underline 2001 income tax return, so that I know I come to a piece of evidence. And within the file, you will have an original and 2 copies of the 2001 income tax return, so that what you have inside your witness file is the script with the questions. And within your script, you've underlined notice to compel, request for production of an income and expense declaration. Every place that you have one of these exhibits, you've underlined them. And you have your script on top, and you have an original and 2 copies of each exhibit, paper clipped together. Exhibit 1, and you have your next exhibit, and you have them all in order in that particular witness's file. And each file is kept like that, okay? And you are ready in that manner. So, original and 2 copies, paper clipped together. What you're going to do when you're standing in the courtroom is you're going to have one marked as evidence. You're going to, since I've been in the courtroom, I can see it clear like this. You're going to write, when the clerk puts Exhibit A on this one, you are going to write an A yourself on your own exhibit, because you need to know which one is Exhibit A, and you're going to give a copy to the other side. Because if you don't, they immediately start yapping.
I'd like to see what Miss Yeamans is giving to the court.
So that doesn't have to work. You want to do this very smoothly, see? Oh no, that was a man. So you want it smooth. See, my cases go really smooth. So you say, oh, I'd like to have this marked for evidence, and you're marking an A on yours. and I'm handing a copy to opposing counsel. That's if you haven't already exchanged exhibits or things. So you want it smooth. You don't want any yapping, or at least any more yapping on the other side than is necessary. So that's how your case is going to go. Smooth, okay? Because you're using the trial in a box. Now, so you've got everything, and you have a whole series. If you have a whole series of witnesses, you have a whole series of files, just like that. And you have a file, you have a, in your box, you will have a file which is labeled notes, especially if you had a trial that lasted days, weeks, whatever. At the end of each day, you would rip your notes off up here, off your legal pad, staple them. Of course, you put the date, taught every day that you were in court. You staple them and you put them into your trial notes file. I keep my notes on a computer or a laptop, of course, when I'm in the court. Now, I recommend that while you are in court, you keep your trial, your notes. So it's, I mean, you don't have to write notes up here, but you're going to have your date. And the notepad, has a line down here. The way I do is I take my notes over here in the event that I'm taking them by hand. It's not a big trial, it's just a short thing in court. I'm taking my notes over here and reserve the space over here on this side of the line when a witness is testifying to write questions down. Write things that the witness is saying down over here, and as you think of questions to ask them, put them in the margin. Then when you go back through, you will not forget your questions. And there's a level on which it is more important to write down questions that you're going to ask them than it is to write down things they've already said. The court reporter is writing down the things they're saying. You could pay them for a transcript, but you can't get the question to ask them again. So you need to have your notes written down. I also use a red pen to write down things that I need to do, and a black pen to write down notes that I'm taking. Now, in the trial in a box, the last file is always argument, because the last thing that you're going to do in the case is always to argue. And as you're going through the file, through the trial, through the hearing, when you think of something that is not clear, you need to make a note and put it in your argument file. You're not going to argue just to be having exercise of jaws flapping at the end of the case. The judge, if the judge is reasonably conscious, they're getting the basic points. If they're not reasonably conscious, it probably won't help to argue. So let's assume the judge is at least semi-conscious, and that's why you're going to argue to them. So you don't have to argue the most basic, obvious points to them. But if you made some points that were a little difficult to follow, you better argue those. And if you can, of course it's a good idea, before you go to your hearing, to put your argument points about your non-obvious points into your argument file. It's a good idea to put your legal points that you think the judge may not know, and I hope you have checked out your judge, and are you dealing with a new judge, that it's this judge's first day on the bench, in which case he really may not know? Or are you dealing with an old-time family law judge, and chances are extremely good that this judge does know the law. So how much law he knows or she knows depends on how long they've been there too. It depends on how non-obvious the legal point is. So you put your things may come out of your law file after you argue them in the case. They may go into this argument file. So as you go through your case, if you think you've introduced a piece of evidence, but you don't think the meaning of the evidence is obvious. Sometimes you do a trial and you lay down a bunch of tiles in a mosaic of truth, and you got each of the tiles laid down, but the picture that's formed by those tiles isn't really obvious. Argument is for the purpose of saying what the whole picture is, and you need to get that done. And so you put your little notes in there, and there are two possibilities with argument, especially if you've done a whole trial. If you're lucky, you may get to go home with type prepared. But sometimes it happens that your trial gets done at 10:30 in the morning and the judge looks at you and says, in my case, okay, counsel, go ahead. And then you stand up and you argue out. And then you're glad all those little pieces of paper are in there and you're ready to go. So you better be ready right now. And that's when trial in the box comes in handy and you've got your argument file and you don't start going through pages and pages of yellow notes thinking, oh my gosh, and also boring judge to death. So this is when you try to do it with a structure. You don't put the most important first and try to have a high point at the end and do a good argument. And that's when trial in the box is going to carry you through from the beginning of your trial to the end. And I think you're going to do a good job of presenting the truth in a convincing way. That's it.